busted up train. Didn't plan on losing my heart tonight, but on that greasy rooftop it all felt right. On the roof of the Waffle House, love gets loud. While Dixon's in the kitchen, we escape the crowd. He might motorboat me like a big old beast, the Lord have mercy. He smells like he's might not be forever, might not be clean, but on that rooftop, I'm his queen. Don't wear pride, we climb that ladder just to let it ride. No white picket fence, no wedding ring, but the way you touch me makes the rafters sing. On the roof of the Waffle House, love gets wild. While Dixon's in the kitchen, we escape the crowd. He might motorboat me like a big old beast, but Lord have mercy, he smells like he might not be forever, might not be clean, but up on that rooftop, I'm his queen. His queen. Don't wear dentures, I don't wear pride. We climb that ladder just to let it ride. No white picket fence, no wedding ring, but the way you touch me makes the rafters sing. Oh, leave the minivan, leave the 9 to 5, hop in your Beetle, let's feel alive. With Dixon, fried bacon, and a jukebox on, we found the kind of love that don't feel wrong. On the roof of the Waffle House, love wild. I'll do broken hearts, lost but proud. He might not be pretty, might smell like yeast, but tonight on this rooftop, he's my feast. Might wreck my home, might break routine, but on that dirty rooftop, I'm his queen. I'm his queen.
Seen screens of awooga ladies. What's going on? I don't know what a awooga lady is. But what's going on is the first hearing in the Karen Read civil suit, or more correctly, the O'Keefe family civil suit against Karen Read, the Waterfall Bar and Grill, well, the consortium behind it, and the consortium behind CF McCarthy's. And as I said in our earlier stream today, always trust but verify. And I'm going to share something now that I can't verify because Howie Carr is putting out on the twit status conference in the Reed civil case at 2 p.m. in Plymouth Superior Court will be live streamed. Should be big. The names of the hacks, corrupt cops, and McAlbert Reed is planning to sue after their failed lynching of her are expected to be made public today for the first time. Ostensibly, the hearing is about O'Keefe's family's suit against Karen for wrongful death, etc. But in addition to asking for dismissal of some of the civil complaints against her, Reed's lawyers will also fill in judge on Reed's plans, namely her own impending mega lawsuit against the state police and assorted McAlberts. Alan Jackson is in town for hearing, but most heavy lifting today will be done by Damon Seglison, local lawyer who will be handling much of the impending civil litigation. Seglison is expected to name each and every defendant in Karen's upcoming lawsuit. Should be very, very interesting. In addition to Jackson and Seglison, a bevy of other lawyers will be in attendance for Karen Read. This is the start of what you might call payback. Sadly, Meatball Morrissey is not expected to be named as a potential defendant. Prosecutors in Massachusetts has almost impregnable immunity, which also applies to Hank Brennan, the special prosector. Hoping to have Seglison on my show sometime after hearing ends. We'll also have sound cuts on the air live streaming as soon as they occur. Developing. So, according to Howie Carr, this could be an interesting, interesting afternoon. I don't know if the judge will allow it. I'll allow it. Or they'll say, well, you have to wait. You can file that in another case. We'll try and have a look at it, find out what's going to happen. Could be very interesting. Could also be that the judge said, not the time and the place. I hope it's going to be fire. So we don't know. But on the face of it, it's just a hearing, status hearing in the O'Keefe's charges against her, where they are suing Karen Reed for the death of John O'Keefe because she was drunk and was driving impaired and not handling her vehicle in a proper way, which we know from the lawsuit. Well, there's a extrapolation of her BAC that, according to the analyst, shows that she was impaired, but there's also witness testimony that she drove her car perfectly normal. She was using indicators. She wasn't spinning all over the road. We have the tech stream data said she was driving at a reasonable speed for the conditions. So I don't know how much they are getting away with. There are also all of the emotional damage that the family endured for seeing their son at the hospital. Remember, the amount of damage was so bad that Paul O'Keefe blew her a kiss, and Mother O'Keefe, old Pexter herself, said, "What's she doing here?" Not saying, "Oh, I better go see if she's okay if John passed away." Because it's a loving, caring family, the O'Keefes. Gearing yourself up to be offended today. Well, Brandon, can you offend Betty Swallows? Is Mo joining me? No, I haven't invited Mo. But Jamie's here. I should invite Mo. Jamie doesn't want to talk to us.
Hi. Sorry, I was fixing my audio.
And that she didn't seem drunk in general. Yeah, no one said she was impaired. Remember, they are suing the two bars for over-serving her. But not one person testified that she seemed impaired in any way. Actually, quite the opposite. The only trustworthy people from that night, the Kolyakakis, clearly stated she wasn't slurring her words. She was totally herself. So, audio.
There you go.
No video. Yeah, get to it. Well, it's America. You can sue for anything.
Civil has a lot of different standards.
He would like to do status first, then the Rule 12s, but he also said to me if you could check your calendars for trial date.
Is it very loud, Jamie?
All right.
Okay.
Good to go. You let us know we're ready.
Finally, a courtroom where we can hear something. She might make them third-party defendants as well. Yes. Miami Spice, ice. You can't hear it. Have you tried turning on your audio? It's very quiet. It's blowing my ear holes.
Yeah, there's like a lot of noise, background noise right now.
His name is Wolf. think Marissa, she's just old. She can't hear anything. Du weißt, wie es geht, wenn Frauen älter bist. Dann kann sie nicht mehr hören.
Good one.
Yeah, it's just Marissa. She's getting older. There's a lot of people. Nice courtroom. Oh, look at Mama O'Keefe.
These are huge.
Hey, Kimpi. Sue, I think you have to also check your connections. Can't see Paul's balls.
Good. Because I will pass on that.
He's wearing blue today. That's his I'm thinking of you color.
Gross.
She's just waiting to see if there'll be a payday, and then she'll leave.
Mhm.
Just Masado said there's such a difference because there's parking, it's big, it's open, there's air, so it's so nice.
All right. Good afternoon, folks. Good session. Please be seated.
Good afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status.
Sears' last one-night stand Superman the hoe, so Betty decided the protein is dead baby batter is better than having sheet glued to her back as a kid. Brandon, you need a new computer. I'm not sure all of this is correct. This is like when Dave does text to speak.
And for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well. Thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor. Damon Seligson on behalf of the defendant Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay.
Good
Good
afternoon,
afternoon.
Your Honor. Christopher George on behalf of the defendant Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay. I'm sorry, you say the waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor. Attorney General also on behalf of Waterfall Bar and Grill.
His accent sounded like he's Swedish. Son is Swedish. It sounded Scandi, and son is how I think that's how Swedes end their last names.
Excellent.
Good afternoon, Your Honor. Looking Rose on behalf of the defendant, CF McCarthy.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all were going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel?
Oh, we have a mouth breather. Welcome to the club. Not guilty, not guilty. You lost. Move on.
And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor.
Right.
So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants. That's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant, and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay. All right. Procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected, then they collectively conspired to ensure that what happened in the house was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed. Regardless of how the court decides those, we still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be in a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff. We're under extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Agreed. Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but there are a lot of records, as I understand it, that are still to be produced so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right. Thank you. Let's hear from C.F. McCarthy, then.
Your Honor, in a similar vote as to Waterfall, we were putting finishing touches on our discovery responses. The last leg of it is just collecting communications from employees throughout the incident, some of whom no longer work for C.F. McCarthy's, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then in terms of the response to the procedural issue that was raised in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would expect
Not how the court
that-
system likes this stuff to work, folks.
Like, I would expect the courtesy of the meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right, any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But
place.
it is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to.
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court.
The confusion here is the 1983 motion, which is a Massachusetts law that makes it possible for civilians to sue the government or yeah, you can sue the state government employees, but that's federal. And that's why it's a little tricky. And the judge is sitting here saying, can we even blend these two different cases? So it's going to be an interesting, because if you didn't catch it, the MSP Tully Bukaki Proctor for civil rights violations, failure regarding retention and training, and conspiracy. Brian Albert, Nicole Albert, Matt McCabe, Jen McCabe, and Brian Higgins for conspiracy. Town of Canton, Canton PD for not securing the Sally Port and the garage are what they are trying to get in, where she's being sued for the wrongful death, and they are then trying to bring these people into the same lawsuit as well. On Mondays, we do chess, because if you want to give a thick mummy the Chewbacca while barebacking one of Val's alpacas, your arms better be effing swole. That's why I did triceps today.
So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time 8 parties involved in this case, correct? There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027, with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now. So I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest, maybe a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But to have two depositions, for example, of parties in two separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. We'd like to brief it if the court gives us that permission.
Okay.
If you recognize the voice of the judge, he was the one who denied Krusty her attempt to get a restraining order against Aiden back in 2020.
Right, on that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. The cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is pled in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
Thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can. Waterfall?
Yes, Your Honor, we have the Waterfall just very briefly. I think the distinction here the council's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't from a relational standpoint close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Cake Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. If you've reviewed that case, I'll give this case site, 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss? No, Your Honor. No. Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations for purposes of a motion to dismiss have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iagino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
Yeah, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor. Does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden. So long as the court looks at the allegations holistically, if relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test.
That's the same as in Georgia. They call them generals. It's just how they pronounce other lawyers as they are brothers and sisters.
For such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor, JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee.
Because they are going by what the police believed. This is a civil court. The ruling in the criminal court has nothing to do with this. And you just need the preponderance of the evidence. So if just 50.0001% of the jury believes she did this, even though she's not criminally convicted of it, then she will be found guilty and liable for John O'Keefe's death. Go back to the OJ case. It's exactly the same thing that happened there. Innocent in criminal court, guilty in civil court. And it doesn't help that everyone keeps saying, well, she was found not guilty. Because this is civil, the other was criminal. There's 2 different court cases. And no matter how many times, because I've seen a lot of people putting on the twit, well, she was found not guilty. This is civil. It's different. It's a new case. And she will have to fight just as hard, if not harder, because in this one, you just need 50.00001% more likely she was guilty than not, and she'll be found guilty. In criminal court, you will need beyond a reasonable doubt. Here, it's just, yeah, it's probably her.
Plaintiff in this case is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically, and 1 to 2 hours before.
Again, you can, but you will have to prove that I did it. They will rely on the same evidence as in court. Maybe the jury will believe them this time. They just have to make the jury believe she was drunk. there is an extrapolated alcohol test showing she was impaired. And then they just have to make the jury believe she backed up. They will use the going forward, going backward, going forward data again. You can sue me for whatever you want. You'll most likely lose 95% of everything you sue me against. But emotional distress for dressing up like a transvestite could potentially land you some money, even though I warned everyone. So you can sue whoever you want, and you just have to convince the jury that you are right. This is America. You love your lawyers.
Or JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost two parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has...
There's no cap on it, as I can see, but it has to do on factors, severity of the injury, duration of suffering, and impact on daily life. In medical cases, it's $500,000.
Already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action. one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I will refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness,
it was stupid when I read it, and it's stupid when
it is very different from learning that your close family member has died.
She is the niece that we don't mention the name of because she is a minor. The niece who changed the testimony to say that Karen told her she had hit him, which she didn't say to begin with. But after spending time with her loving grandma for a couple of years and Jen McCabe and all of these people, she all of a sudden remembered that Karen had told him, I hit him. Well, that's not what she said, but I hit him is what she's claiming. And the line about we can sense with other senses was stupid when I read it in his motion back in the day, and it just sounds stupid again. This is not the argument that you can't perceive a traumatic event if you're blind, but it has to do with the closeness to the event. And thank you, James Bond. You brighten days, Baker. Thanks for the humor and wisdom. Thank you so much. And Sebastian, hey Baker, I hope you had a great day. You too, chat. Well, this is my 3rd stream today, so it must be good.
That is upsetting. It will be upsetting to anybody. But to have experienced
Isn't she
the
still
event or
17?
the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenk, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct.
And I bet Brandon is right now searching what is Boyles versus Wenk.
To be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's in the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seen before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability. And yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to read.
What? She assumes editorial control over a blogger. How the hell? So they're going to call Aiden as a witness in the civil case, and he will have to testify, yes, I gave up all my editorializing and just wrote what Karen Reed asked me to read to cover up this crime. Chances that's going to happen is about as high as me getting laid. Settle. This is, come on now. I know it's a civil case. You have to fight for your clients, but this argument is stupid. And as Jess says, yes, you make the argument because you have to, and to kind of like we talked about earlier today, you try to hit all the magic words that make the judge say, well, there kind of is a case there. Mm-hmm. But just imagine calling Aiden and he's going to go there and said, so you gave Karen Reed full editorial rights to your blog post. No. Well, isn't it true that no? I'm a massive asshole. I would never ever give my power away from me because being an asshole is my power. I have my blog because people like my gonzo punch you in the face style. I wouldn't give that away. They already tried to prove this, and a grand jury said no. Jesus Christ.
Reporters, the O'Keefe family's period of grief has expired, and they are now fair game. Discovery will track how much leaked information defendants should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case sits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine.
Have you proved she has editorial control on any of that? And again, waiving her Fifth Amendment right, this is a civil case. It's way different with Fifth Amendment, because if you claim the Fifth, they can use it against you in a civil case.
Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more.
She hasn't been on Turtle Boy.
This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments.
What?
They should.
There is no legal standard finding people innocent. They're guilty or not guilty.
Know that plaintiff's susceptibility and vulnerability are at issue in this case, and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit, part of the car accident, gets up, runs to see his son. It's contemporaneous, it's at the time of the event, and the court didn't have the same spatial, relational, and temporal concerns that the cases speak
No, a lawyer can spin as many yarns as he wants in a courtroom, almost.
to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that it might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to assign a trial date, we could do so. I mean, literally, I've talked to the clerk, we could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You got a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties, and there's relatively not.
No, he said 8 people. The O'Keefe family is 5 people. Karen Reed and the 2 bars. So that's 8.
Theories as I'm hearing it, but nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point.
No, they have none of what they need. They have no depositions of the McAlbert family.
In raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers, your clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring.
Booz, again, this is a civil case. It's not the same case you just had.
If you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still, it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have two ongoing, as far as I understand, the two businesses in Canton are ongoing, and they have their business decisions they have to make ultimately. They're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you you could do as soon as this spring if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do whatever.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here in Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure.
How many days out you want to go for? 60 days, 90 days?
Yeah, probably 60 days.
50 days? November 21st, Friday in the end of November.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly, as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery, and any motions, Rule 15 motions to amend or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor.
All right.
That's that.
That, as the young kids say it, was that. The big surprise is Massachusetts State Police, Tully, Bukaki, Proctor, they are trying to shoehorn them in for civil rights violation failures regarding retention and training and conspiracy against Karen Reed. That would probably be part of her 1983 motion, which is a federal, but potentially the judge could shoehorn it into this one. Then Brian Albert, Nicole Albert, Matt McCabe, Jen McCabe, and Brian Higgins for conspiracy to cover up what happened. That should be able to be put into this one. Then the town of Canton plus the Canton Police Department not securing the Sally Port and garage. Again, most likely a 1983 motion, which is a civil lawsuit against the state. This will take forever, potentially. this is civil court. It's not criminal court. A lot of people have to understand, and I know it's hard because you're reasonable people. So it doesn't make sense to you that she can be sued in a trial where she was just found innocent. But it's a civil wrongful death lawsuit we are having here. It's not a criminal case. She can't go to prison. She can be ordered to pay a whole heck of a lot of money to people, or she can be found not guilty. But it's two different trials. A lot of people are sitting on Twitter right now and say, well, they can't do it. She's found not guilty. Double jeopardy. Have you ever heard about it? O.J. Simpson.
Mhm.
O.J. Simpson went to prison for stealing sports memorabilia. He didn't go to prison for killing Nicole, even though he was found civilly liable for it. So again, it's two different systems. This is a monetary court. It's not a criminal court. It has nothing to do with the MSP or any of them. This is civil. And people have to understand it. It doesn't matter that she was found not guilty in a different court. Nothing to do with this. The level to find her guilty is also way lower in civil court.
Mhm.
This is a money grab for the O'Keefe family, nothing else. That's why they sued the bars. That's why they sued Karen Reed, but they didn't sue the McAlberts. Because the McAlberts, if Karen Reed is guilty by drinking, why aren't the McAlberts who drank with him and then invited them over there not also guilty in his untimely demise?
You got me.
Is it because you're good friends with the McAlberts, you didn't sue those? Or is it because, just like Paul O'Keefe, you can't cut the hair of a bald person? Paul O'Keefe is in his own legal civil trouble because that idiot drunk drive and hit an elderly person who is now suing him for damages. And there's a lot of talk, and I can't find anything on it. There's a lot of rumors out there, but so far I have seen nothing about how the money from the GoFundMe and the fund that or the trust that Karen Reed set up for the kids, how they have been spent. I have no access to that. There's a lot of rumors out there. He got a new backyard. He got a new porch, whatever. We don't know because we don't have any insights in their economy. But I don't think Paul O'Keefe has $200,000. And if she put the kids' money in trust, he can't touch them. Because those money is probably bound to be paid out for school or for college or something. You can't just go in and say, well, I'm going to rate the trust. So at least the trust funds should be there, unless he had found a loophole to steal that money. And that's going to be a problem because then the kids can sue him. But again, you can't cut the hair of a bald guy. That's a Danish saying for it doesn't help who has no money.
You and your
Rafferty is also being sued. Yes, Paul is being sued for damages. Rafferty is. She actually has two things against her. I think one for damages and one because she had tried to had it dismissed because she tried to put the blame on the city because she was driving a city vehicle, and the court said, "Fuck you! You're not on duty. You weren't supposed to be driving that vehicle." Well, it's going to be a very, very expensive punishment. I'm saying this is a money grab because they are suing the bars as well. One of the things bars have is insurance. They will have a certain amount of money where they say it's not worth paying a lawyer for this trial is going to, at least if they don't speed it up, we won't be done with it till 2027. At that time, Jamie will have fired me. Marissa might have unalived her husband. Jemima is living in the Caribbean with the money she embezzled from Brandon. And we will be a totally different place. But imagine how much money CF McCarthy's is going to spend on having a lawyer look at this. So they have to do a cost-benefit analysis and say, what's the likelihood that we're going to pay out? And how much time is it going to take for us to prove we're not going to pay out? Because they'll probably go, let's say the O'Keefes will accept $10,000 from CF McCarthy's and the Waterfall Bar each. They will be out of there in a jiffy. If the O'Keefe will go to Karen Reed and say, hey, let's squash this. You admit no guilt at all, and your insurance company pays us $20,000. Wouldn't she be in the best interest to take it? Her insurance company would say, we're going to pay it, because what she had sitting there today, that's a whole heck of a lot of money. And then she can focus on attacking the 1983 motion against the state and the police. Because if she could get a lowball settlement and admit no guilt and get this out of the way, so she has all her power to go against the people she's suing, I would do that. Because just like insurance companies, do you know what cities are really fond of? Paying you to shut the fuck up. So if the O'Keefes weren't money hungry, they would come in with a lowball offer and say, well, it's just for the kids. Can we get a combined $100,000 or something like that? The insurance company would say, yeah, fuck it. We're going to waste more on lawyers. Let's get out of here. And then Karen can go after the main target, because Karen, she's not going to win anything by going to court with the O'Keefes and bleeding them dry. That's not where her energy is best spent. Her energy is best spent against the 8 other people she just named today.
Well, I kind of
Well,
agree with some
insurance doesn't care about if the collision hit or not. The insurance are just doing this. Oh, you're offering us to settle for $10,000. This is going to be 5 lawyers over 2. Yeah, we'll take it. No admission of guilt. No admission of guilt. Fine. Here's $10,000. Hasta la taco. We are out of here. It's all about how. Have you seen how Gina Carano, who got fired, and Disney paid her a big bag of money not to talk about her being fired? Happens all the time. She was really gung-ho and she's going to sue them and she's going to prove her. And then she got paid and then she didn't really feel for the First Amendment and everything's fine. No admission of guilt and you're out of there. I think the bars have a burden if any of the defendants do. I write personal insurance and the carrier will pay it. They don't. The bars will pay. I was surprised that the bars didn't already contact the O'Keefes and gave them an offer, that they said, well, fuck it, we're going to jump on the Karen Reed wagon.
Yeah. I'm kind of surprised too.
I'm sorry, Marissa, but yesterday I think we talked about you planning to take his life, so you're going to be in trouble anyway. If she were to settle, they would need to be some non-disclosure and non-disparagement clauses. Yeah, they will. AJ could bake a nice settlement offer, and all of us shut the hell up. And if you ever mention Karen Reed, you forfeit everything. Get the hell out of here. That's why she's going to use her energy is best used attacking the people she want to attack. I love all insurance companies. They efficiently help us all. Yes, insurance is always great. You just have a small co-payment and a very, very low monthly payment. But in case you need them, they will be back within 6 to 12 weeks. Now for 10,000, she would be crazy not to take it. I just made up an offer, but let's say in reality, if you were sitting in Karen Reed's chair and they came in and said, okay, we're willing to 25,000 to each of the kids. Us grown-ups, we do nothing. It's put in a fund. We can't touch it. It's for the kids for their school. You can shave it however you want between you and the bars. No admission of guilt, non-disclosure, non-disparagement clauses on all of us. How is this to you? I would say thank you, please. And then I would sue the city, I would sue the McAlberts, and I would sue the Popo. Because again, she's not getting anything out of this other than expenses. She is not gonna get anything from the O'Keefes. She might be able to get awarded some expenses, but the easier thing would just be to pay up. Over 6 figures for a leaky ice maker with your option to not only replace on like-kind basis, but just to go ham. As an example, say you know some old people, you may have been inside of one. Have you been inside an old person? And they have an E&S homeowners policy. Yes, that flood destroyed your childhood possession, but did they pay out well? Over 6 figures for a leaky ice maker that your option to not only replace on a like-kind basis, but just to go ham. Do they write that cheaply anymore? Not really, but you can find it with the right broker. Yeah, and again, these insurance companies who works for bars, and this is not a single bar they work for, it's a conglomerate of bars. They settle all types of cases all the time because they really don't want to have CF McCarthy's in the news every time Karen Reed goes to trial. So CF McCarthy's, let's say again, I'm just making up a number, 50,000. The bars would probably come and say, okay, we'll swing for 15 each and you'll pay 10. We'll pay 20 each and you'll come with 10 just to get our name out of it. And then you're free to go after the ones you want to go after. There's all the vindictiveness you want to have. You want to punch Peck in the face, all of that shit. But is it worth it? In the end, because you will just have to pay to punch Peck in the face. It's not that funny to punch people in the face. It would be more funny not to give her the satisfaction to sit there and lie about you again on the stand. And you can do that for a very low price, I bet you. AJ is pro bono. And I think Liza Little is there pro bono as well. I don't know about the rest of them. I don't know. In this case, they might get good publicity in that Karen has a lot of support behind her. Yeah, but again, for bars, let's say they lose. Wouldn't you pay 10,000 to make that go away before it happens? I mean, at least you're getting some coitus by the water, though. I would like some coitus. I don't think it's about money for them. They want her to be found responsible. I don't think so. Let me be absolutely honest. Remember when Paul O'Keefe was sitting on his back porch? I saw green in his eyes. I didn't see responsibility. I don't, Jamie. What have you had any other? Do you think it's for JJ when we think about how John O'Keefe has been?
No, I kind of agree that I think he wants to, he wants not her held responsible for JJ, but like he wants that guilty. Or not guilty, but he wants this to, he wants to take her for all she's worth because I think it's a lot to do with money, but I think it's a lot to do with his pride too. Because of all this.
Yeah. You can always negotiate after judgment too, though. Yeah, but you will still be found guilty. Let's say C.F. McCarthy's. Yeah, you had a hand in this man dying. They would rather not have that judgment against them. And the insurance company don't give two fucks about Karen Reed. They have an Excel sheet and they're looking at hours, money, and possible settlements. They don't care. I'm sorry to say it. I know your insurance broker is the nicest person in the world and he promised you this is the best offer you can get. But if your house burns down, you're not sleeping on his couch. They are only in it for the monies. Pride, the glazed donut guy, yeah, probably not. Oh, it's money. Peggy wants money. She had no one to blame for her daughter, and now all her grief is being channeled in one direction, and money is gold. She didn't even like John when he was alive. Yes, we know this because they were fighting to make him take the kids because she didn't want them. And I'm sorry. I feel sorry for her loss. But that way she was talking about her husband on the stand showed me her soul. She's a piss poor human being, in my opinion. I know Jamie and Mo laughed when she was, oh, I've been married for 42 years. And then she came back at it. And to me, it was so spiteful the way she came back and said, it's way too long or something like that. I found it so disrespectful for a man who has apparently stood by her in everything, who sat by her in court. A man she couldn't even take to church, who Karen Reed made sure got to church during COVID. That horrible woman disparaged him in front of God and everyone on live TV. That showed me she's a bitch. I'm sorry for her loss. Just like I'm sorry that Kevin has cancer, but he's a massive idiot. That's not because of the cancer, and the cancer didn't cause him to be an idiot. He's just an idiot. I can feel sorry for their loss or their illness or whatever they have and still say they are horrible people. And Peg O'Keefe, to me, with what she showed on the stand, in the way she talked about a man who has spent eternity with her, probably almost every day thinking, how the hell can I stay away from her long enough so I don't have to hear her sound like I pissed in her morning cereal? She's a horrible woman, in my opinion. My parents were married for 42 years. Wasn't sunshine and roses. My mom had she lost a man to cancer. My dad was actually the in the ambulance who picked him up and drove him to the hospital the last time. And then 2 years later, they moved in together. And he took her 2 kids. Me and my sister came along. They stayed together for 42 years till he sat at the hospice holding her hand. And the only thing she said after 42 years was, do you think we did all right by the kids? This kind of a woman didn't spend 2 seconds on the stand before she disparaged her husband. The only thing my mom thought about was, I hope the kids are okay. My sister came home from Switzerland, spent time with her that day, and her only thing she was thinking about was, how can I make sure that the family will stay together when I'm dead? Because we are all over the place, the family now. That was what she was thinking about. This woman, I see her as exactly the opposite. She played everyone against each other, and she despises everyone. I bet you she hates her husband because she didn't get the life she wanted. Do I know her? No. Have I met people like her? Yes. Well, Fedorowski, it's a good Christian channel. Jamie will give me Bible studies if I don't do it.
I will.
I can understand why they avoided putting her on the stand for the first trial. Yeah, she wasn't a good witness. My mom and dad were married for 62 years. Yeah, and it probably wasn't. It wasn't all sunshine and roses. But I bet you your mom would never say the same things she did, because she didn't do it with a smile in her eyes. She did it the first time, and then she just had to come back and put the knife in. Yeah, he probably cleaned the garage a lot and took extra shift at work. I'm way behind everyone else. What is Paul smirking at? His case is going to tank and he's smirking. We don't know if he's what. I don't know where you are. Your mom and dad is still married. Yeah, and again, of course they had arguments, but my mom always said about my dad, the thing that made it work was they were so different and they had their own interests, but they were always together about the family. And that's probably what makes things last. That you can go away, and my dad liked to do his veterans stuff from the Air Force. My mom liked her politics, but they were together raising a family of 4 kids with low-paying jobs and still giving us what we needed and taking stray kids in that we found out on the street, say, hey, you want to come stay with us for a couple of months? That was her life. I just can't see Peg O'Keefe ever doing that. She'll charge a homeless person rent if he slept in her driveway.
Wasn't.
Well, my parents did. We didn't have that big of a house. They yeah. No, but as my dad said, it's all about adjusting to each other. I couldn't do it in my marriage. That's why I'm not getting married again. But smart words. Yeah, and he's probably done the same thing as my dad. He just got the down. Whenever she talks, just do the It works on every woman.
Yeah. My mom and dad are still together, and sometimes I don't know how.
My husband gives me the good spot on the driveway. 20 years later, who could ask for more? Exactly. It's the small things. But interesting when we're going. Apparently, we'll be back on November 21st. It's a Friday. It's a Friday. We'll probably have some motions before then. Potentially even maybe some of them wants to talk a plea, but not a plea, but some kind of settlement. We don't know. The judge wants them to do it. The O'Keefes, I think it's ridiculous what they're fighting for. But hey, money, money, money must be funny in a rich man's world. It's an ABBA song, Jamie. You should know it.
I don't.
Have you seen Mamma Mia?
No.
Go watch Mamma Mia when this show is over.
Oh, okay. Get right on it.
Penilla?
Good?
No, it's horrible.
Okay, and then why would I watch it?
Meryl Streep sings worse than I do.
Then why would I want to watch it? It's horrible.
Because you need to know the musics.
Oh my God. I'll just look up ABBA by myself.
Yes, Gypsy Muse. I just sent it to my mods while we were on dinner break. I'll look into it. It seems really odd. If you don't know about, I think his name is David, or is it Deford? I think it's David. I don't know. But
yeah, I don't know.
apparently his Tesla was left on the roadside. Oh, and thank you so much, Slidey Pied. Thank you for covering the trials you do. Thank you so much, and thank you, Anime. I had it on the YouTube chat, so I didn't see it. So thank you so much for alerting me. So I remembered my Rumple rant. Slidey Pie. It's so annoying it doesn't show up in the same chat. But let's say David. I don't know. He had a Tesla apparently standing, left it at the side of a road. A person who had been missing for a year and a half, sorry, I just skimmed the headlights, is found in the Tesla's boot of the front. They don't have an engine, so they have a front boot and a back boot. I think it's in the front because it's an impound lot, and it starts to smell really bad. So they find the decomposed body of a missing girl who's been missing for a year and a half, 2 years, something like that. Young, 15, 16 years old. I'm probably going to do a video on it tomorrow, but it's not going to be today because this is my third stream already today. I am the front trunk. Thank you. So this is another case that's going to be interesting. Sadly, we can't watch it because it's California, but it's kind of interesting. A young girl who was very, very underage when she disappeared. I think she was 14 when she disappeared.
Wasn't there a guy too? I thought there was two people.
No, that was a woman. And he was on tour. Then he canceled the European leg of the tour, and then he canceled his entire tour. So far, I don't believe any charges has been brought against him. I think he might have been contacted by the Popo, but I don't believe any charges have been brought against him so far. I'm going to do a little bit of a deep dive on it and maybe make a video, maybe do a live. I'll see what's out there. But yes, I have seen about the David thing. There was a video circulating showing him cleaning shoes similar to the ones the girl was wearing, but I don't know if it was real or not. Jemima, if it's on the internet, it's always 100% real. Because on the internet, you're not allowed to lie. The best ABBA covers were done by Erasure on the ABBA-esque EP. I don't like Erasure. He was supposed to play a concert in Norway when they found her, I think. Yeah, I believe he either just had been in Denmark or was supposed to be in Denmark. So, yeah. No charges. He is cooperating. Thank you, Gypsy. I'll look into it and see what is people dropping his Discord chats. It's kind of like in the Karen Reed case. Everyone is sending all of their DMs around and trying to stab each other in the back. Jamie, I'm going to give everyone your DMs.
No, please don't.
Okay, be there by 9. It's my phone day. I'll see if I can make it.
Yeah.
See you later.
Oh my gosh. Like, who is this guy anyway? I've never heard of him. Is he?
He's a rapper.
Okay, is he from America or is he?
Yeah, he's from LA or Jamie.
Okay.
I'm gonna make a video on it tomorrow. Maybe watch the video. Sometimes they're okay.
I don't know. I might check it out.
Thank you, Jamie. Enjoy your honest coverage of court cases. Thank you, Baker. I'll cover it. I don't do the legal stuff because I'm not a lawyer, and I try not to oversell anything because there's enough BS on the internet. So I cover it the way I would have liked people feeding it to me, because I go by the good old thing that Razorfist said: if it's not on online the way you like it, just make it yourself. And that's why I did it this way. His bodyguard is really sus. We're gonna figure it out. He's a rapper and a Fortnite player. I hate him already.
Oh God.
Guilty.
Ugh.
Shax is gonna listen to Dancing Queen.
Oh,
you should. That's a good ABBA song.
Sean, you do that.
Am I gonna dress up like a girl? I never dressed up as a girl. Well, I dressed up as Jamie once for Halloween, but I had never done it else.
You were so pretty.
Yeah. People said it was the best you ever looked on a stream.
Yeah, they couldn't tell the difference.
So, but the rest of you, it's 9:30. The birds are chirping. The wind is blowing. There's a Dr. Pepper cream soda waiting with your name on it. Go out, enjoy that one. We'll be back tomorrow. I have no plans, but remember Wednesday, I believe it's 2 p.m. Aiden will have his big day in court this week. I know people are out there begging for Betterow to come on a show tonight. Maybe give Betterow a little. He has a big day in court Wednesday. So temper your loins. I know you really want Betterow, but maybe give him just what?
Temper your loins.
Yes.
The way you phrase stuff.
Cool your loins then.
Temper those loins, people.
Serenative, could you bring me I don't know how close you are at the border, but could you bring me a lot of Dr. Pepper because it's way too expensive. I have to pay like $1.50 to get a can of Dr. Pepper in Denmark. It's cheaper down where Serenity lives.
Jeez.
Aiden is in court Wednesday with his big 88 pages motion. Jamie had hired someone to cover that motion on my channel, but they only got to 31 pages before Jamie fired them when they lost their copyright against me.
They had to go.
Yeah. Aber YouTube 35 hours after this. Enjoy. I can't see Plevin on YouTube. I think he has me blocked. I'm sorry.
That's sad.
I theoretically can be at your front door in around 5 hours if the ferries run on time. Are you in East Germany? I don't want to support Grant. I didn't really, what's his? Oh yeah, Grant is up there. No, but you can't. No, his chat is only for moderators because everyone is a fucking moderator on his channel, and I don't want to. That absolute autism.
It's the worst
He is the worst.
He is the worst. He's a terrible streamer.
No, I'm going to send you somewhere else, somewhere you've probably never been before. Give them a donut from me. Jamie, hasta la taco.
Bye.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
So you literally
Then you
built
don't
a cannon?
need the ferries.
Yeah, it's pretty awesome.
All right, I'm in love. Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.